is now in session.
Good morning. You may be seated. We are here today on Jessica and Braden P. versus DCS. Our case number 1, CA JV150040. Counsel, as you all know, each side is allotted 40 minutes, or a total of 40 for both sides, 20 minutes aside. The clock on the podium reflects the amount of time you have remaining. For the appellant, the time remaining on the clock includes whatever time that you have decided to reserve for rebuttal, if you choose to do so. So you're in charge of keeping track of your own time. We record these proceedings, so when you approach the podium, both times for the appellant, please give us your name and the name of your client, so that when we go back in the recording, we'll keep the parties straight. With that, you may begin.
Good morning, Your Honors. May it please the Court, I'm Jeff Morris, representing appellant Mother Jessica Peterson. I'm joined at the table by co-counsel Deanne Gillespie-Strube, who is also representing appellant Mother. With leave of the Court, would like to reserve about 5 minutes of my time for rebuttal. This case represents two strong issues and failures of the department in this case. The first one is the department's violation of the parents' due process and their fundamental liberty interest in the care, custody, and control of their children, and also an insufficiency of evidence, which I will get to after addressing due process. There are three main problems under the due process. As the Arizona Supreme Court recognized that in a dependency proceeding, interference with a parent's liberty interest can only be done by strict compliance with the statutes involved. First two issues under the statutes that are involved is first the department's failure to properly investigate under ARS 8456, as I recall. And the reason why this becomes a problem is that the department's poor investigation led to a reporting of false information throughout the court proceedings, additionally to providers. The result of this false information that gets perpetuated, as well as a failure to obtain information that would refute the allegations, as the department is required to do under their investigation. They provided this information to the providers, stating that this was a matter of fact, that Mother had in fact overdosed, that the kids, the twins, had in fact been caged. And similarly, in making reports to the court, this information and their reports puts in front of the court information that the parents are not able to refute until the time of trial. And this creates a kind of a cognitive bias that the parents are unable to counter. The overlap with Joshua J., as this court had heard.
Look, if you're going to go on to the time thing, let's pause and talk about the cognitive bias issue. It seems to me that to the extent that the agency has failed to properly investigate the facts, you and the other, your co-counsel did have the opportunity at trial to bring out your view of what actually happened, your view of the facts. Is your argument that the judge was improperly biased somehow by the reports in the evidence that showed a different picture?
In part, yes, Your Honor, but not as a matter of fault for the judge below. And this is where the overlap of the timing issue comes into play, where the department is able to, for 13.5 months, provide information that's false to the court as well as to providers. And that information sits in the court's mind so that when trial does eventually start, there is a bit of positioning that has already taken place.
But due process is just an opportunity to be heard, an opportunity to respond to the allegations that have been made. And so putting aside the timing, it seems to me, as Judge Johnson has pointed out, the opportunity to rebut whatever is there. If the state is guilty of overreaching, they look bad when you point that out, I assume. So I'm having a hard time with the due process aspect of it. And if it's just the time, isn't that something that should be pursued separately? If there's a concern that this is lingering too long, can something be done prior to that, to whether it's a special action or to make an objection saying we absolutely need to go to trial sooner?
Yes, in part, Your Honor, and would counter also in part. As Your Honor recognized, that besides the timing issue, the due process requirements is the opportunity to be heard. And that becomes this part of the argument. However, as your question also said, was that is there an opportunity for mother to rebut? And the concern that comes there is that it's the state's burden of proof to establish that there's a dependency by a preponderance of the evidence. If we have to come in and have to rebut, there's an implied assumption that is occurring, and as a practical effect, is occurring in the juvenile courts.
But let's say this a hearing took place within 30 days or 60 days, a very short amount of time. Is there any kind of due process issue? The state makes charges that, in your view, are overblown, but you have a hearing within 30 days. Is there any due process component that's violated?
On that short of a time frame, we would argue not. But that starts to get into the timing issue that you wanted to avoid earlier. And having that kind of ruling, I think, from this court would overly burden the department. In a way that children who are at risk of very serious harm, it could become a problem for the department. We're not seeking that kind of bright line rule under the statute for due process.
Did the parents make a due process argument in the trial court at any point?
Your Honor, if I may answer your question and go on to another aspect before reserving some time. Yes, there was a due process objection.
When was that made?
It occurred in the February hearing, but it dealt with a timing issue.
And that was when a continuance was granted because the court found that the mom had failed to produce mental health records. Yes,
which is problematic on its own, that parents are being required for strict compliance, but the state isn't. It becomes an issue.
What other occasions did the parents make a due process argument as to either the timing or as to the cognitive bias issue? I'm unaware of a cognitive bias issue that was specifically addressed, as well as for the timing. The other was a written objection by fathers in about May or June, as I recall. And if I may... Or later on in the summer.
Yes, ma'am. Your Honor, if I may also address another due process issue, which was that the state was constantly arguing, and there's some overlap, and but it's also an independent issue, that the state was arguing that because the parents had not admitted wrongdoing, there was a dependency. And the reason why there's overlap here is that failure to investigate, which creates this presumption that parents have done something wrong, therefore that parents have to admit that they've done wrong, is a cause, as an independent cause for dependency, violates due process, because the parents are essentially told that they are not allowed to contest the allegations. If they do, there's a dependency.
Is your due process argument focused on particular statutes or rules, or simply on the conduct of DES, now DCS?
It's kind of mixed. For the most part, due process. Where the statutes become involved is really on what the state was trying to show implicitly for whatever there might be for a severance. And this is where we briefed that there's a timing issue, that, of course, the parents, after the dependency, must, seek to address the underlying causes that brought the children into care. That's the Rule 59 issue as well as the severance issue. But what we're dealing with here is the department is also stating that because at the time of their parents are not admitting their guilt, that the actions alleged in the petition lead to a dependency, there must be a dependency, which is strictly the due process question, not involving any particular statute, Your Honor.
If we are aware of juvenile court records, which the last time we looked seemed to say that all of the children now have been returned to the parents. Is that still the case?
Yes, Your Honor, that is my understanding, that the children are all returned to the parents.
Is this appeal moot?
It is not moot because the effects of a dependency last.
Does the dependency continue as of this date?
I'm not aware if the dependency has been dismissed, Your Honor. I apologize, I just don't know that. But the other cause for concern is that there is a dependency, and the timing went so long on trial that there is, in fact, one of the grounds for severance that's partially established, which creates an additional issue of prejudice.
Out of home.
I'm sorry?
Out of home.
Out-of-home placement.
You're
Yes.
talking about out-of-home placement is enhanced by this long period of time.
Yes, sir. Agreed.
It's interrupted and they've been returned for several months. Does the time period continue to run? Does the time period count against them if there were a new severance proceeding?
Your Honor, if I go to the statute real quick, which is 533, I believe. As I recall, it doesn't address whether or not there had been an intervening period. It just says under 8, the child has been in out-of-home placement for a cumulative period of 9 months. And then, some other circumstances under the statute that don't appear to apply to your question, Your Honor. And then
talk to us about the timing. This dependency took an extraordinarily long time to conclude. What could the parents have done when they first met with Judge Ishikawa and he looked at his calendar and he said, the first time I can give you a hearing date is 6 months away?
At that time, as I recall from the record, there was some discussion about whether there would be another judge, I believe Judge Hauser, that might be able to give an earlier date. But at that point, there had already been an issue where Judge Ishikawa had set dependency adjudication sometime in late 2013, but for some reason it went to Judge Anderson, who vacated those dates, and then afterwards found out that she couldn't be a judge in that case because she had been timely noticed. So she sent it back to Judge Ishikawa without, reinstating what she had just vacated. And so then when the parents and the department went back to hearing in August, that's when the judge said, I have nothing out until February. And at that point, that kind of back and forth with Judge Anderson kind of creates a reservation to go to a different judge to deal with the same type of issue.
Did they make any assertion at that point? No, that's simply unacceptable. We can't wait 6 months.
Not in August, no. They did waive time in August. When it came up for February, that's when, and there was the continuance, that's when Mother's Counsel strenuously objected to any more time before trial. And then if I may just spend a little bit of time on the insufficiency of evidence issue.
Sorry to interrupt, but so how much time was there after the objection?
So from February, and then the ruling was in January, so that would be 11 months. The trial itself started in May, concluded in November, so the trial itself went 6 months, and then the decision a couple months after that. On the insufficiency of evidence, the reason why this is a problem, and we briefed it considerably, and so a lot of it I'll rely there since I'm coming up short on time, is that the department is relying on suppositions, hypotheticals, leaps of conclusions to show really the three basic findings: that mother was unfit. There was actually no evidence presented that mom is unable to parent. It requires an inferential leap that was directly refuted by not only her doctor, but also the caregiver supervisor, Warding Taylor. For the use of the baby gates, I mean, it's... the baby gates in Arizona are a common safety device used throughout Arizona. And the department seeks what is essentially a strict liability standard. One of their employees stated that if she had even seen it, the two baby gates, which were stacked on top of each other, used once, she would have removed the children immediately. But notwithstanding, it's a non sequitur that use of baby gates necessarily requires that they're being neglected, because baby gates restrict a child to an area. If one baby gate doesn't do it, then it's as if the gate's not there. If there are two baby gates there, it doesn't change in the view of the child that there's any difference in being restricted to a certain area.
But wasn't there essentially undisputed evidence of mother's inability to parent for, say, 1 day, with whether it's because of a medical illness? And would you agree with that, that there's on at least one occasion where she's, just because of medical issues, she's unable to parent?
On one day there was an event, late March, but even then that medical event didn't state that she was unable to parent. She actually did parent. She placed her children behind the gates as a safety measure to protect her children while she was being taken care of by emergency responders. It requires a leap in order to get to mother is medically unfit to care for her children. And then lastly, the Aiden's school records, as briefed, is a post-removal collateral attack on mother seeking appropriate care before he was removed, that the state's own evidence showed that he was improving before his removal. And if I may reserve the rest of my time.
Thank you.
Thank you.
Good morning. May it please the court. My name is Joanne Falgett, and I'm representing the Department of Child Safety in this case.
Before we begin, do you know that the current status of the dependency?
I checked on Friday, and it was still pending, so I assume it still is as of today.
Okay.
I will also start with the alleged due process violations and would point out that these issues were not, in fact, properly raised and preserved in the juvenile court. First of all, regarding the issue about investigation, The department is not required to find every single relevant fact when it does its investigation. It is required to do a thorough investigation and to do a reasonable job of doing that. The department did, in fact, investigate. The department was out there in January of 2012 investigating a report of potential neglect. The report stated that the kids were behind the gate for extended periods of time while the parents slept, that they often had dirty diapers and a dirty home. Kyla Mead investigated at that time. Megan Carey testified that the first visit in January had been a scheduled visit. The gate was there, blocking access to the room. The girls were not at that time in the room. They were in the kitchen eating. Because the grandfather and the father were both there and able to care for the kids, they did not remove them at that time. Went ahead and closed the case as unsubstantiated at that time. But then in March of 2013, when the paramedics and fire department were called out to the home again, mother apparently had either OD'd or otherwise become very ill and was losing consciousness. And when the paramedics and fire department showed up, the girls were, in fact, behind the gate. And Aiden, the older child, told one of the firemen, Captain Pukta, that the girls spent quite a bit of time behind the gates, that he would often feed them by pushing bowls of cereal underneath the gate, and that father, went off to work, and that the girls spent substantial time during the day behind those gates. So when father arrived home about 20 minutes after mother had been taken to the hospital, father didn't let the girls out from behind the gate. So although there was some evidence that, mother had said, or as he's arguing, that she had merely put them there as a safety precaution, there's also substantial evidence that, in fact, it's the norm for these girls to be in their room behind those gates. In any event, these concerns were reported to the department. The after-hours investigative team went to the home. They found corroborating evidence. In fact, the home was dirty, and the children were there, the gates were there, but they found that the father was currently, at that moment, able to care for the children, so they didn't immediately remove the children, but referred it to the regular investigative team to handle it. They went back on March 22nd, 2013, and the department's investigators went to the home, found that mom stated that she had just woken up. The girls were awake and behind the gates in their room with the TV outside the room, them watching it. There was a strong odor of feces as they walked into the front door of the home. The girls' diapers needed to be changed. The home was still in disarray, despite the fact that the after-hours investigative team had told them that they might want to consider cleaning it up. Again, father wasn't home. So again, we have more evidence, another instance where they're showing up at the home and the girls are behind these gates, not being very well cared for. Mother at that time admitted that she had been unable to care for the children because of her medical issues. So the department also spoke with Carrie Sheelan, who was the family services specialist who had spent over 2 years going to that home every week. Maybe missed a week here and there, but basically every week for well over 2 years, and stated that most of the time when she was there, the gate would be up, and a lot of the times the girls were behind the gate. She said she didn't see a lot of parent-child interaction. She was concerned about it. She had considered reporting it to the department, had discussed it with her supervisor, and that she regretted not reporting it. The older child, Aiden, was allowed to roam through the house. She also expressed concern that although the girls had been born premature, initially they were hitting all their developmental milestones. And it wasn't until they were 18 to 24 months old that she had begun noticing the delays. A reasonable inference from this is that the more time those girls spent behind those gates, the further behind they were developmentally. The department then provided a rapid response team to evaluate the girls after they were taken into emergency custody. And the team found delays in 4 of the 5 areas that they test for. They found delays in fine motor skills, social skills, speech skills, and problem solving. The girls were average only in their gross motor skills. Their ability to climb apparently was just fine. When they were first brought into care, the twins had substantial behaviors related to feeding. They would have tantrums when they saw food at the foster care home. The parents would overfeed them at visitation. And Kristen Kidd, the case manager, testified that at one point the parents overfed the twins so much at one of the visitations that one of them had to be taken to the emergency room. So there were ongoing indications of inability to parent appropriately, and substantial evidence of the dependency, and substantial evidence of not just an initial investigation over a couple of months, but a continuing investigation of the situation and an attempt to get the parents to go to counseling. They did a psychological evaluation, and the psychologist, Dr. Giuliano, recommended counseling. He did indicate, however, that mother appeared to be rather defensive, and so he was concerned that it might not go well, and indeed it didn't. The parents.
What's the turning to the timing?
Okay.
Here. What is the position of the agency about the situation that we have in the juvenile court today, where parties come into court, they're entitled under the statute to a timely resolution, and they're told the first day I can provide you with an hour or two of hearing is 6 months away?
It is a very difficult situation, and believe me, there's nothing the department wants more than to expedite these cases, but the juvenile courts are currently really overloaded. The legislature, it's nice they set these deadlines, but then they don't fund enough judges to actually handle the calendar that results. And so it's certainly not the department's intent or the department's fault if there is no time on the judge's calendar. I would also point out, though, that the parents contributed to many of the delays. First off, at the very beginning, they had waived time in August. They had set a time, I believe it was February or March.
Well, that's not real. The first 6 months, they didn't complain about it, but
right.
They didn't contribute to it, did they?
Right, but then beginning when the trial was supposed to start, I believe it was February or March of 2014, they had failed to disclose records that they had been required to disclose. The court was required to continue the hearing because of that, and so that set it back a little bit further. And again, difficulty finding trial dates that met everybody's schedule. At the June 11th 2014 hearing, father's attorney was arguing for more time so that they could, quote, have a full and fair airing of all of their evidence.
Which was their right.
Which was absolutely their right. But again, to ask for more time and then complain when it takes time to get it because of the judge's calendar and to try to blame that on the department is a little bit unfair, perhaps.
What could parents have done anything just from the outset?
Well, I mean, as I believe you mentioned before, certainly they could have filed a special action. They could have at least brought it to the juvenile court's attention that they were, in fact, going to object. They did not want it to go on, but instead they repeatedly asked for more time. In August, father's attorney had a family emergency, and the court vacated that hearing date. Mother's attorney did not at that time say, no, wait a minute, let's at least take some testimony that's relevant for mother's case and continue go ahead and have part of the hearing.
Of course, by then, the dependency had continued for 15 or 16 months already.
Absolutely it had, but again, they had repeatedly waived time and failed to object to the setting of a new trial date and had on at least 2 to 3 different occasions asked for more time. So again, to have them at this point asking this court to overturn the decision when they in fact contributed substantially to it taking as long as it did is just, and to try to blame the department for the judicial calendar, it just doesn't, the department did nothing to deprive them of due process. The court, in fact, father's attorney asked them, and mother's attorney did not object, asked the court on July 18th to make a finding of extraordinary circumstances under 8-842C because they were beyond the time limits under the Joshua J. case. And the court obliged and made a finding that there were extraordinary circumstances because of the attorney and court schedules. So, again, they didn't subsequently object to the length of time. They asked for more time in August and in October. And So it's a little difficult to see how they are now arguing that the department or even the trial court violated their right to due process by giving them the full and fair hearing that they requested. Mother is also arguing that somehow there was this cognitive bias because the hearing took so long. And I would just point out with respect to that the trial court is presumed to be able to consider all of the evidence presented and give it the weight that it's due. And many hearings go several months. And to make some kind of an assumption that the trial court can't remember properly the evidence or consider new evidence properly without any evidence to support that is improper, certainly, at this point. And again, that's an issue that they didn't raise for the juvenile court to consider. Perhaps if they had, the juvenile court could have done something different if it needed to. But I think at this point, the presumption is and should be that the juvenile court was able to properly consider the evidence that was presented to it.
Maybe this is a good time for me to ask.
Certainly.
Does the department argue that this appeal is moot or unnecessary?
No, I actually agree that it's not moot. I mean, certainly the dependency is still pending, and in addition, as he points out, there are other collateral consequences to having had a dependency finding. So, no, I wouldn't say that it's moot, but at the same time, most of the issues that they have raised are either waived or, at this point, sort of moot.
What is, procedurally, so we'll understand, hopefully, what is still pending?
Well, the dependency, there has been a finding of dependency, and the case is still pending. The children are still deemed dependent, although they're being transitioned back to the parents' homes. And presumably, once the department has fully determined that the children are in fact going to be safe in the home, then the dependency will be eventually dismissed. If that doesn't happen, and if the parents are in fact remain unable or unwilling to provide appropriate parental care and control, then I assume at some point a termination petition might be filed, or at least the children removed again.
Are there statutory or perhaps by rule time limits for that require the department to make up its mind on whether it's going to dismiss the dependency or to pursue something further?
I will have to confess that off the top of my head, I don't know what those timelines might be, but I'm quite sure there are some timelines and that it will be handled as appropriately as possible. Again, the children were just removed at the beginning of, returned to the parents at the beginning of June, I believe it was. There was an order issued at the end of May, and then a separate signed written order for just the girls issued a few days later in June. So June 15th, maybe. So it hasn't been a real long time yet.
What's the evidence before the court, other than the school absences, to support the proposition that the son was neglected?
Well, again, to the extent that mother was completely unable to care for the children when she was ill or feeling so much pain or on her pain medications. And I would also point out that both mother and her doctor did testify that, at times the medications did affect her. She admitted she had been unable to care for the children on March 20th. The doctor testified that certainly her medical condition and the medications that she was on could impact her ability to function, and that is why she had prescribed a caregiver for mother, which then they had hired father to perform those caregiving duties, and he happened to be absent quite a bit when she apparently needed him. So the evidence...
Was father expected to not have a job, or was he expected to be at home during the day, or what hours was he expected to be there for the... I don't remember the number, whether it's 26 or 32 hours a week.
Yeah, I believe it was up to 32 hours a week that he could work, and he testified that he was required to submit actual timesheets. I don't know that there were any set hours that he was required to be home, but that he was required to, assist mother in caring for the children when she needed it.
He wasn't home that amount of time each week?
I don't know that it's so much that he was required to be there. They were going to pay him for that much, but part of the January investigation was that if father and grandfather were going to be available to assist mother in caring for the kids, then the kids would not be removed at that time. There was no formal plan put in place, but that was the agreement verbally between the parties, according to the case manager, that they would not remove the children, assuming that father and grandfather could provide the assistance that mother needed. So it's not that he was required to be there X number of hours per week. It's that he would get paid for up to X number of hours per week. But he was required to assist mother with and make sure that his children were cared for, both under the agreement with DCS and as a matter of parental responsibility. I mean, if your spouse can't care for the children, it's your job to care for them. So to the extent that
the department does seem to suggest, because they arrived at the house and the baby gates are up, even though the kids aren't in there, but the fact that the baby gates are there, that suggests some inability to care for the kids. Why do they have to necessarily take down the baby gate if they can get the kids in and out of the room? And why is that such an issue, just to have a baby gate up?
Well, if it were one baby gate, it might not have been quite such an issue. The testimony was that they had started with a 2.5-foot tall baby gate, and when the girls learned to climb over that one, they added on top of that an additional 3-foot high baby gate, so that there were 5.5
But you noted
feet.
that the baby gates were up when the children were out of the room.
At least
So they were
one
out
would
of the
be
room.
up when the
And
children were.
So why would the baby gate have any relevance at all? The kids aren't in that room.
Just sort of an indication that it's being used pretty frequently if they're leaving it up pretty much all of the time. And in addition, the human.
But doesn't every house has a door on? What if they're just in a room? There's a door. That door could be closed all the time.
Sure, and if the kids aren't in there, yeah, I understand what you're saying. But on the other hand, what the family services provider from Southwest Human Development had stated was that she was very concerned because it seemed like that gate was up pretty much every time she went there, and the kids were behind it a lot of the time. She saw very little parent-child interaction when she was there on many occasions. Sometimes the parents would come and work with her with the developmental tasks that they were working on, but many times they would not. And so her concern was it just appeared that, you know, she's only there an hour a week, so she couldn't say for certain, but it appeared to her that they were using those baby gates an awful lot to keep the kids secured away from the family. And the case manager testified that she had been to many, many homes over the years with babies, and typically people use baby gates to keep the kids confined to the room that they are in, not confined to a room in the back of the house where you can't even see the children. And so a reasonable inference from the combination of the fact that that baby gate was up, the kids were behind it a lot, and the fact that they became more and more developmentally delayed the older they got, the family services specialist said she was very concerned that the parents were using those baby gates inappropriately to kind of keep the kids away from the rest of the family. Aiden, meanwhile, was apparently developmentally appropriate, and he was allowed to roam free through the house. The family services specialist was very concerned that the girls were not getting appropriate interaction and appropriate opportunities to develop speech and social skills and so forth. So they're sort of intertwined. You know, the developmental delays, they got worse as the girls got older, and the fact that those baby gates were just always there, and 2 of them, to really keep them confined in that room. Also, there was some concern about safety issues. I mean, apparently the firemen who showed up on March 20th stated that he had started to try to remove the baby gate and let the girls out, but he couldn't figure out how to undo it. And when they arrived, Aiden was unable to open the front door to let them in. So there was some concern that if mother's home alone with the children and there's some kind of emergency situation, and she can't get up because, you know, she's having medical issues, that Aiden wouldn't be able to get the girls out of the room or help them escape to safety if that was necessary.
And what about Aiden? Come back to
that,
you started to tell me
that Aiden wouldn't be able to.
No, I asked, what's the evidence that he was neglected?
Oh, again, he ends up being pretty much the caregiver for these girls, sliding food under the gate for them and pretty much taking care of his own self as well, which is a little inappropriate for a young 5-year-old child to be having to take on that parental role. Additionally, if mother is unable to care for any of the kids...
That is based on his statements. This is a 6-year-old who's recounting time. Seems a little bit unreliable to rely simply on a 6-year-old statements about how long something's been happening.
I don't think there was any discussion of exactly how long, but the way that he had phrased it, it sounded like it happened frequently, and it wasn't just, oh, this morning I got them some food, but I always slide them food under the gate. I see that my time is about up, so...
Thank you.
Thank you.
Mr. Morris.
May it please the court again, Attorney Jeff Morris representing appellant mother. To address some of the questions that were raised, Honorable Johnson, I believe, asked, is there an issue with, the timing of the court? And the answer was that the court is overloaded, not as a fault of the department. The courts are overloaded because the department is bringing cases like this where the evidence is so sketchy and unreasonable they haven't investigated, that there are just a ton of cases. And as Your Honor recognized, that it's an issue at the trial court below to the point where parents feel obligated, and the bar representing the parents feels like it's a no-win situation because there's a feeling that there's going to be a presumption that the court's going to agree, and that on the timing, the parents are going to be removed from their children for a length of time unless they stip and satisfy the department's thirst. Another question by Your Honor was, is there a timeline to dismiss? No. And part of the answer from the department is the department determines whether or not, well, no, it's the court decides that the kids are safe. The department can have an opinion, but they don't determine. It's the court. And then Judge Johnson, you asked about the school. Besides the school absences, what evidence is evident Ada neglected? There isn't. Mother's issues of health. There was one medical event, but otherwise, and this goes to another question that was asked about mom. Her medical issues. There's an inference that's being made that she's medically unfit, but the doctor said no. Having a caregiver does not mean you're unable to parent. And the doctor said she is able to parent. And the caregiver supervisor said, yes, she is able to parent. I've been in the home. Things are fine. And so there's a conclusion there that mom's unfit when she is not. And then Your Honor asked about, the baby gates. You're right. It has no significance because there's doors that could be used. And the answer about one of the providers being in the home, she was in the home for 2 years, 1 hour every week, never complained to anybody until 14 months after there's a dependency petition. Then her testimony is, oh, yeah, there's a problem. There's the inference there's a problem because this has been going on. This dependency has been going on for 14 months. And in fact, the statements about her actually having problems are belied by her own reports. That's for 2 years she was saying she has these check marks that say, yes, the kids are doing this, the kids are doing this. It was a Cheers report.
Thank you, counsel.
I'm sorry? Thank you.
Thanks to both sets of lawyers for your briefing and for your argument. We'll take the matter under advisement and issue a decision in due course. We'll now stand adjourned.